I'm Bo Johnson. If you have not purchased the report on jamesbowersjohnson.com about a conversation between a subscriber and ChatGPT concerning the Liberty Dialogues, I encourage you to do so. The report will not be up there much longer. This report is important, especially given the context of today's video. Americans must understand the relationship of jurisdiction and government in general. So please go to jamesbowersjohnson.com. It's not designed for profit. It's only $1, and it's priced this way for those that genuinely want to understand. It's 50 pages of information that will enlighten you. It's very much worth the price of admission. Now, yesterday I released a video explaining the federal government's case against George Norris. A subscriber on Yes to Hell With, someone who is very thoughtful, someone I respect, someone with whom I've had real dialogue, looked at the record online of this case and concluded that the government was right, that Norris was guilty of smuggling orchids from Peru into the United States. Now, I don't dismiss that conclusion. I respect it. But I believe it reflects a conclusion reached too urgently, without enough reflection, and without enough attention to a deeper and far more dangerous problem. So I sent this subscriber a video, not commentary, not opinion, but a primary source, a YouTube video of George Norris and his wife explaining in their own words what happened. In that video, they explained that it was a clerical error, that they were not smuggling, that they did not believe they were doing anything wrong. And that takes us to the central divide in this entire discussion. In criminal law, there is actus reus, the criminal act, and there is mens rea, the guilty mind, the evil intent. You do not become a criminal merely because a form is wrong. You become a criminal when you act with intent to violate the law. This is perhaps the greatest divide between the conclusions reached by government agencies and the reality of justice as it should be. And this is where the system breaks. If the federal government cannot engage in what I call a common man conversation, if it cannot knock on the door, ask reasonable questions, assess intent, and distinguish between civil noncompliance and criminal conduct, then the system itself is inherently flawed. I see it no other way. Before I accuse any man of wrongdoing, I want to ask questions with discernment, with the intent to gather knowledge, with the goal of arriving at a conclusion that is balanced and just, not one that coerces a confession simply to mitigate harm down the road. In the federal government's case against me, the Assistant United States Attorney Charles Hogaboom presented a theory to the jury that was as simple as it was dishonest. His argument was essentially this: he filed before, he's not filing now, therefore he must be guilty. If he did it before, why is he not doing it now? That was his theory of prosecution. What Hogaboom did not tell the jury was that I wrote to the IRS, the Department of Justice, and other federal agencies asking a basic question: what statutory liability compelled me to file income tax returns? What he did not tell the jury was that I wrote to the federal government explaining that I was no longer within their jurisdiction, that I received no federal benefits, that I was not operating within the federal orbit. What he did not tell the jury was my good faith belief, the very thing the law requires jurors to consider. What he did not tell the jury was that the federal government and the IRS agents involved never answered my question. Instead, Hogaboom appealed to resentment. Why isn't he doing what you do, he asked. Why isn't he paying his fair share? This, in my regard, is not an honest man. This is not an honest U.S. attorney. This is not prosecution. This is moral theater. It is the conduct of a morally bankrupt individual operating within a system designed to reach a guilty verdict rather than the truth. And the same pattern appears again and again. Look at Orlando Carter. No one knocked on his door with a notebook and a pen. No one calmly showed a badge and said, "Mr. Carter, we're here to clarify something." No one asked the most basic question imaginable. Mr. Carter, did you ever have a $4 million loan with PNC Bank? That single question, asked in a civil manner, reasonably and in good faith, would have gone directly to the actus reus and mens rea. And yet it was never asked because the conversation is dangerous to a system built on presumption. You see, the federal government presumed that the suspicious activity report submitted by PNC Bank was valid. They did not dare question the honesty of PNC Bank. This is the flaw. This is the disease. The system does not want clarification. It wants leverage. It wants escalation. It wants compliance through fear. And this problem is not isolated. It is not rare. It is not theoretical. This is a book in my hand called Prosecutorial Misconduct. It is filled with thousands of cases and examples of thousands of officials, investigative agents, policemen, lawyers, defense lawyers, prosecutors, judges who have gone awry of ethical conduct or the law itself. They're not pursuing the truth, they're pursuing convictions. So every year across this country, there are documented cases of abject corruptness and outright evil by public officials. Police officers planting evidence, police officers destroying evidence, officers going so far as to place red paint into a woman's underwear to simulate blood in order to make a rape charge stick, judges doing unconscionable things behind closed doors to ensure a conviction, prosecutors withholding exculpatory evidence, misleading juries, and manipulating facts to secure a win. This is not negligence. This is not error. This is moral collapse, and it is abhorrent. Then it gets worse. Anyone familiar with the court system and the appellate process knows that the quote-unquote record is treated as sacrosanct, and the government loves this. Many cases reach appeal without what should be there ever making it onto the record. In my own appeal, I was not permitted to enter or rely upon my good faith beliefs as required under United States versus Cheek. In Orlando Carter's case, the record did not reflect a government forensic financial audit establishing that there was a $4 million loan or not. The record is not truthful, not because truth does not exist, but because the government is not just in a general sense. My objective in using the Norris case is not to become a Monday morning quarterback and debate over evidence. It is to expose a structural flaw in a system that curates the record, forecloses truth on appeal, and then hides behind the sanctity of what it controls. Based upon my knowledge and experience, I question anything the government does, and this is exactly as it should be. I did not imagine this problem. I documented it. I wrote a book called The End of Justice. And the source of this crisis is not legal complexity or procedural confusion. It is the soul of man, the very corruptness of man. It is the willingness of men and women in positions of authority to abandon conscience in exchange for profit, promotion, convictions, career advancements, and headlines in the press. When public officials do immoral things to win, to climb, and to be praised, this is not justice. This is a predatory process. And a country that tolerates this behavior is not a free country. It is a morally bankrupt country. It is a country that is no more. The premise of The End of Justice is simple and undeniable. America is the most incarcerated country in the world. We cage, and I use that word on purpose, we cage more human beings than any nation on earth, more than authoritarian regimes, more than dictatorships, more than countries, we are told, are less free. And here is the unavoidable conclusion. If we are the most incarcerated country in the world, we cannot be a free country. Freedom and mass incarceration cannot coexist. One defeats and destroys the other. What we are witnessing in cases like George Norris, Orlando Carter, and countless others is not an anomaly. It is the logical outcome of a system that rewards convictions over truth and power over conscience. Until that reality is confronted honestly, no amount of freedom, rhetoric, or procedure will save it. And that is the truth. And as always, may truth reign supreme.